Welcome to the Supreme Court Podcast. All opinions expressed in this podcast do not reflect the views of the Supreme Court. For clarity, the text of the decision prevails.
Erwin Alvero was charged with violation of Section 5, Article 2 of Republic Act No. 9165, or the Comprehensive Dangerous Drugs Act of 2002, for the illegal sale of methamphetamine hydrochloride or shabu with a total weight of 0.1459 grams. He pleaded not guilty during arraignment, but later filed a proposal for plea bargaining. During the presentation of the prosecution's evidence, citing the ruling of the court in Estipona v. Lubrigo, he asked that he be allowed to plead guilty instead to violation of Section 12, Article 2 of RA 9165, invoking AM number 18-03-16-SC, or the plea bargaining framework in drugs cases. The prosecution objected and manifested that Alvero's proposal is not acceptable, but the Regional Trial Court of Roxas City, Branch 16, resolved to grant the proposal. When the RTC denied the prosecution's motion for reconsideration, the Office of the Solicitor General, representing the people of the Philippines, filed a petition for certiorari under Rule 65 before the Court of Appeals. The CA granted the petition and ruled that the consent of the prosecution is essential in plea bargaining. Aggrieved, Alvero elevated his case to the Supreme Court. Are trial courts authorized to allow plea bargaining when there is an objection from the prosecution? Hi, I'm Attorney Mike Navallo, Supreme Court Chief Communications Officer. It's the 28th of February 2025, and today we talk about when a plea bargain should be allowed or disallowed by a trial court within the context of the case of Erwin Alvero versus People of the Philippines, GR number 260214, decided on April 17, 2023, penned by Supreme Court Associate Justice Maria Filomena D. Singh. And joining us to talk about this case is Court of Appeals Associate Justice Raymond Reynold R. Lauigan, member of the Philippine Judicial Academy's Department of Criminal Law. Hi, Justice Lauigan. Thanks for joining us and welcome to the Supreme Court Podcast.
It's an honor and a privilege to be here to discuss about the topic pertaining to the case of Alvero versus People.
All right. So, Justice, before we discuss the case, let's talk about plea bargain first. What kind of procedure is this and what's the logic behind it?
Plea bargaining is part of our criminal procedure and it's embedded in our rules of procedure, the rules of court. It's a way whereby we can dispose of cases quickly, and actually I call it a win-win situation for both the state and the accused, because the state would get what it wants, which is to punish and penalize the offender, and the accused would be spared of the humiliation of a protracted trial. And the end result would be to lower the penalty to such a reasonable period where the accused can be penalized for the offense he committed.
And Justice, is plea bargain available to all kinds of cases, or are there specific cases where this applies?
Generally, it would apply to cases that would not be heinous in nature, and it's also applicable to drug cases.
But before, I remember, Justice, that plea bargain used to be prohibited in drugs cases under the Comprehensive Dangerous Drugs Act. What's the reason behind this? And I also note that in 2017, there's this case, Estipona versus Lubrigo, which declared that particular section, Section 23 of the Comprehensive Dangerous Drugs Act, as unconstitutional, so therefore allowing plea bargain. Can you walk us through the history of plea bargain when it comes to drugs cases?
If you go over the previous drug laws in the Philippines, the penalty was not that much, such that people or offenders would just violate the law. And the lawmakers came up with Republic Act 9165, which provided for stiffer penalties. And the reason why they brought up the prohibition under Section 23 of the law is to be able to implement the provisions of 9165 and not allow the accused to get away with whatever offense committed through the process of plea bargaining. In Estipona, That was one of the issues raised in that case. And the accused questioned the validity as well as the constitutionality of Section 23 of RA 9165. And the court in that case declared Section 23 to be invalid or unconstitutional because it would be an encroachment on the constitutional mandate of the Supreme Court, being the one in charge for the promulgation of rules on pleadings, practice, and procedure.
And to be clear, a plea bargain agreement is well within the rulemaking powers of the Supreme Court, that it shouldn't be encroached into by the legislature.
That's correct.
Right. And Justice, in light of the Estipona ruling, the Supreme Court came up with a plea bargaining framework in drugs cases in 2018. Can you briefly walk us through this framework? And I know that the DOJ also had its own circular, Department Circular number 27. So if you can describe to us how similar, how dissimilar the two frameworks are.
The SC bargaining framework on drug cases was brought about by a clamor to be able to dispose drug cases, because if you go over the criminal cases that are pending before our lower courts, most of them, particularly in the RTC, most of them, or 80% probably of them, would be dealing with drugs. And considering that, as I mentioned earlier, plea bargaining is a process by which you can dispose of the case quickly or speedily, then, if my memory would serve me right, the PJA, I think, wrote a letter to the Supreme Court, particularly to the Chief Justice, to try to explore the possibility of having plea bargaining in drug cases. And this brought about the case of Estipona. In response to that clamor of being able to make use of plea bargaining as a way to dispose cases, the Supreme Court came out with the bargaining framework. The bargaining framework is, simply put, it's just a table where you can check whether an offense punishable under Republic Act 9165 can be subject to plea bargaining. And this usually depends on the volume or the grams involved for that particular case. Such that, if I may just go over the framework.
Please go ahead, Justice.
For example, in Section 5 of RA 9165, this involves sale, trading, etc. of dangerous drugs. If the volume of shabu would be 0.01 to 0.99 grams, or in case of marijuana, if that would be 0.01 to 9.99 grams, then you can plea bargain to the lower offense of Section 12, which is possession of equipment, apparatus, and other paraphernalia for dangerous drug. In possession, in Section 11, Paragraph 3 of Republic Act 9165, if the drug involved is shabu, and it would range from 0.01 to 4.99 grams, or in case of marijuana, if that would be 0.01 to 299 grams of marijuana, then you can also plea bargain to Section 12 of the same Republic Act 9165, and that also is insofar as possession of equipment, apparatus, and other paraphernalia of dangerous drugs. If the offense is would fall under Section 11, Paragraph 2 of Republic Act 9165, and if it's shabu, from 5 grams up to 9.99 grams, then you can plea bargain to Section 11, Paragraph 3 of RA 9165. As to marijuana, if that's 300 grams to 499 grams, you can also plea bargain to Section 11, Paragraph 3. So these are the only offenses where plea bargaining is available. As to the other, because there are a lot of sections in 9165 that would also be punishable, like, for example, cultivation of marijuana, among others, these are not subject to the plea bargaining.
So in short,
framework.
Justice, there's a layer of, let's say, depending on the volume of the drugs involved and depending on the section that's being violated, there's a certain layer where you can plead to a lesser offense. So it's like there's a gradation of offenses. How
That's
is
that's
this?
correct.
How is this different, Justice, from
Okay.
the DOJ Department Circular Number 27, which I note was passed or was enacted by the DOJ on June 26, 2018, which is just
Yeah.
a few
Yeah.
months from the April 2018 framework of the Supreme Court.
That's correct. For example, Section 5 on sale. I mentioned earlier that you can plea bargain to Section 12, which is possession of equipment, apparatus, or other paraphernalia. But in the DOJ Circular number 27, you can plea bargain not to Section 12, but to Section 11, Paragraph 3. And the significance of that is because in the Supreme Court framework on plea bargaining, if you plea bargain to Section 12, that would only be within the range of 6 months and 1 day to 4 years, and a fine of only 10,000 to 50,000. But if you go by the Department Circular of the DOJ, DO 27, it would be under Section 11, Paragraph 3, which carries a penalty of imprisonment from 12 years and 1 day to 20 years, and a fine from 300,000 to 400,000. So there's a very big disparity insofar as the penalty of imprisonment and fine are concerned.
So it's stiffer under the
Yes.
DOJ
Yes.
Department Circular. And it is...
And there's only one, if I may add, no, there's
Yes,
only
please.
one. Section 11, Paragraph 2 also, which I mentioned earlier, you can plea bargain to Section 11, Paragraph 3 under the Supreme Court bargaining framework. But for the DOJ framework, you cannot plea bargain. Plea bargaining is not allowed insofar as shabu, which is 5 grams to 9.99 grams, and marijuana, which is 300 grams to 499 grams.
And very interesting that you pointed out the difference, Justice, because it is exactly this conflict between the Supreme Court plea bargaining framework in drug cases and the DOJ Department Circular 27 that was the very issue in the case of Alvero, because he was charged under Section 5 and he plea bargained under Section 12 under the SC framework. But the prosecutors were objecting to it, citing their own department circular. So if you can walk us through how the court resolved this conflict.
Okay. The facts, as you just mentioned, he was charged for Section 5, and after arraignment, he wanted to avail of plea bargaining. And knowing that the quantity of drugs involved in that case falls within the plea bargaining framework, he filed a motion to plea bargain. The RTC, following likewise the framework of the Supreme Court, and considering that it falls under that particular framework, allowed plea bargaining. So the OSG, representing the state, went up to us, to the Court of Appeals, on a Rule 65 petition for certiorari, citing grave abuse of discretion, considering that there was an objection on the part of the prosecution. And generally, if you go by the principle of plea bargaining, there's a need for the consent of the state.
Right.
Because it's a mutual agreement before we can arrive at a plea bargaining settlement or plea bargain to a lesser offense. So they brought it to the Court of Appeals. And before us, the court declared that that particular act of the RTC in allowing plea bargaining, despite the lack of consent on the part of the state, was an act constituting grave abuse of discretion.
That's for the CA.
That's for the CA. And that resulted in the accused Alvero bringing it up to the Supreme Court on 45. And the Supreme Court said that, well, the determination of whether plea bargaining would be allowed is a judicial function. If you go by the precise words used by the Supreme Court in the case of, in that particular case, it's not part of the prosecutorial prerogative of the DOJ. Because when we deal with that executive function of the DOJ, that would only entail determination of who to charge, what to charge, and how to proceed with the case. But whether it is an offense or one that can be subject to plea bargaining, that is within the prerogative or the sound judicial discretion of the judge, of the RTC judge.
And it's really this weighing or perhaps this conflict between prosecutorial discretion as well as judicial discretion that's at the heart of this issue. And in this case, Justice, what's a good thing to remember when it comes to this topic of conflicting ideas of, the judge would always argue that it's under the court's discretion whether to grant plea bargain?
Well, there's a landmark case, and that's the case of Monchero, where the court laid down the guidelines for plea bargaining. There are just, personally, there are just three basic things to remember for purposes of guiding the judge whether to allow plea bargaining or not. Number one, would it fall under the Supreme Court plea bargaining framework? And that you have to check on the drug involved as well as the volume of the drug in that particular case.
Right.
Because if it's not within the plea bargaining framework of the Supreme Court, then the RTC judge should outrightly deny the motion for plea bargaining because it doesn't fall within the framework.
Right.
Second, if the ground for the objection would be because of an internal rule of the DOJ, like Executive Department Order number 27, then that's not a ground for objection. And if that's the case, then the RTC can overrule the objection and allow plea bargaining. Because at present, the DOJ already harmonized its own bargaining framework.
So they amended
By-
Department
yes.
Circular 27.
Department Circular 27, now it's Department Circular 18, series of 2022. In those instances I mentioned earlier, where there's an apparent conflict because there's a different offense to which the DOJ would want the accused to plea bargain to, or in some instances where there's no plea bargaining allowed, now it's now in accordance with the plea bargaining framework of the Supreme Court. Such that if the accused would, or if the prosecution rather, would make use of EO 27, then outrightly, the RTC judge must deny or overrule, rather, the objection and proceed to allow the motion to plea bargain on the part of the accused.
Following the Supreme Court framework.
Yes.
Interesting.
And also because there's no conflict anymore. And then there's the other standard which was used in Monteiro and in subsequent cases decided by the Supreme Court. You don't only check the bargaining framework if it falls within the bargaining framework, meaning the offense and the quantity involved of drugs involved. You must check also on the qualifications of the accused. Is the accused a recidivist? Is he a habitual delinquent? Was he repeatedly charged for drug offenses? Does he have a reputation in the community of being a drug user or a drug peddler? Was he already subjected to rehabilitation and did he just have a relapse? So this would pertain to the qualifications of the accused.
And
And if that would be the ground raised by the DOJ, then there's no outright overruling of the objection. The court is mandated to check whether the allegations of the prosecution, specifically on those grounds, are really in existence or not.
And this is what happened in Alvero, Justice, right?
That's what happened. That's what
even if
happened
the
in
Supreme
Alvero.
Court said, yeah, you can use the Supreme Court framework, but there still needs to be a determination if you don't fall under the disqualifications. So is that the reason why this case
That's
was
correct.
remanded to the trial
That's
court?
correct.
So if in those cases, if that objection is raised, are trial courts mandated to hear and receive evidence to prove that they are not within the disqualifications? Under
Yes.
the
And
framework?
if I may add also, no, apart from the qualifications of the accused, then there's another criteria. Is the evidence sufficient to convict the accused? Or stated otherwise, is the evidence of guilt of the accused strong? Because if the evidence of guilt is strong, then the motion to ask for a plea bargain should be denied. So it also goes into the evidence. So the bargaining framework, number 2, the qualifications of the accused, and number 3, the evidence submitted at present, at the time that the plea bargain, the motion to plea bargain was filed by the accused. So these are the basic guidelines.
So there's now, the judges are now also required to look into the evidence that's been presented. So there could be a preliminary determination if there's possible guilt on the part of the accused at that stage.
I would just, let's just go back also to the history of plea bargaining.
Yeah.
Plea bargaining is essentially available at arraignment and during pre-trial, according to the rules of criminal procedure. But Estipona stretch it further. So even after the presentation of the prosecution's evidence, and even after a bail hearing where evidence was already submitted, there can still be plea bargaining according to the case of Estipona. That's why in those instances where the prosecution has already presented evidence, or in bail hearings where evidence was adduced, then that's the time where the evidence is already before the court, and the court can look into the evidence to determine whether the guilt of the accused is strong or not.
And this is why we have this statement in the Montero case, where the court said that the trial courts are in the best position to objectively and disinterestedly assess whether the facts, the evidence, and the circumstances of the accused necessitate a plea bargaining agreement. As impartial tribunals, courts are in the best position to ultimately determine the propriety of plea bargaining in each case. So, essentially, Justice, the courts cannot just accept what prosecutors recommend when it comes to plea bargaining. It has to make its own determination based on the framework, based on the guidelines that's being set.
That's right. And going back to your previous query on whether to remand it or not, if the objection would deal with the qualifications of the accused or whether the guilt of the accused is strong, then there's a need for a hearing. And that's also provided for in the Montero case. Because the determination of the qualification of the accused or the evaluation of the evidence or the evaluation of the guilt of the accused would necessarily need the presentation of evidence. And you can do that in a hearing conducted for that purpose. But there's a case I forgot. I forgot the case, but there's a case decided by the Supreme Court where, because if you go over jurisprudence after Montero, most of the cases decided by the Supreme Court, the dispositive portion would direct the remand of the case to the lower court for the determination of those two things, qualification of the accused and evidence of guilt is strong. But there's one case where the RTC judge already made a determination based on the evidence as to the qualifications and as to the guilt. That's why there's no need to remand it further.
I see. And those determinations are binding on the Supreme Court,
yes, right? Yes. So that for more expedient resolution of the case, it would be better if you would ask me, it would be better for the RTC judge to already make a determination
that early,
such that when the case goes up to the Supreme Court, and if the Supreme Court would find the ruling of the RTC judge to be appropriate and correct in accordance with the guidelines I just mentioned, then there's no need anymore to remand it further back to the lower court.
Just to take into account the factual circumstances, Justice, because if you're plea bargaining and you're hoping to get just 6 months, when you plead to Section 12, the whole process of going to the Supreme Court might take years, right? So that defeats the whole purpose of plea bargaining and trying to get the 6-month period as your penalty.
That's true, and that was also as a side issue. No, probably it's not an issue, just an obiter in the ponencia of Justice Monet, that the duration of the stay of the accused in Alvero was already more than the period for the offense which he wanted to plea bargain to.
Very interesting. And talk about Justice Minette Singh, and she's the ponente in the Alvero case, but she in fact dissented in the Montero case. Her stand, if I recall, is that there has to be consent coming from the prosecutors. And yet, in this case, she acknowledged in Alvero that she has to follow the doctrine set by the Supreme Court. And walk us through that reasoning by Justice Singh, just as a bit of curiosity.
Yeah,
Justice.
because since it's the majority decision in Montero, then it's binding now. It's
Right.
part now of jurisprudence. And unless the court would, by a majority decision, would overturn. I'm not sure if, I think Montero is en banc. So if the Supreme Court would come up with another case, reversing Montero, and also en banc, then that's the only time that the dissenting opinion of Justice Monet, if she still wants to
Right.
pursue that opinion, could now be the majority opinion for the court in this new case.
Right. And we can confirm that the Montero case is an unbanked decision by the Supreme Court. Very, very interesting discussion, Justice. Maybe perhaps just to close our discussion, if you can set for us the importance of having these rules on plea bargain and what the impact might be in terms of congestion, in terms of the dockets, the clogged dockets of the courts. How will this help ideally?
Plea bargaining is a very, very efficient and important tool to unclog our dockets. I experienced that myself. I was an RTC judge for 8 years, and I was able to reduce my docket to less than 100 because of plea bargaining. And if we just follow the guidelines, basic guidelines, framework, does it fall within the framework? Is there a disqualification by reason of habitual delinquency, recidivism, etc.? Is the evidence of guilt strong? If the accused would not be disqualified under any of these instances, and the prosecution is amenable to a plea bargain, then the RTC judge personally should go by and approve the plea bargain for purposes of disposing of the case. Anyway, as I mentioned at the outset, it's a win-win situation for both the state and the prosecution, because at the time you reach in my experience, at the time you reach the plea bargaining stage, then the accused would have already been in prison for probably 6 months to a year, which is a good bargain for the prosecution to punish the accused. And that would also spare the accused from further trouble of still staying in jail and the expenses of having a counsel to defend him in these cases.
What's the safeguard, Justice, in cases where, if you get caught, even if you want to contest the evidence, you want to contest the arrest, but because you just want to get it over and done with, you just plead guilty to a lesser offense, so that is 6 months. When you could have questioned perhaps the illegality of the search or the arrest, or perhaps if there's allegation of planting of evidence. So what's the protection so that people don't just plead guilty to a lesser offense just because they want to get the case over and done with?
The framework itself, the guidelines itself. Because even if you want to plead guilty just to lessen the penalty, if you're not qualified in the first place, because the quantity of drugs you're caught with would be not under the framework, or you have in possession would not be under the framework, then outrightly you cannot avail of plea bargaining. And I just observed, because of the changes in the jurisprudence, that the prosecution would now almost raise as a ground for objecting qualification of the accused, as well as that the evidence of guilt is concerned. That's why the court would now have a hearing. And because of that avenue provided for to have a hearing, then the prosecution can likewise strengthen the presentation of its evidence. And these are, I believe, safeguards to prevent an accused from just availing of plea bargaining to lessen the offense.
And at the same time,
the penalty for the offense.
At the same time, Justice, that hearing could also be the avenue for the accused to raise their objections if there are.
Precisely, yes.
All right. So This has been a very, very interesting discussion, Justice. So thank you so much for joining us today.
Thank you too for the invitation and for the honor and the privilege to be part of your podcast.
And if you wish to read the full text of the court's ruling, you can go to the Supreme Court website and e-library. Just search for Erwin Alvero versus People of the Philippines, GR number 260214, decided on April 17, 2023, penned by Supreme Court Associate Justice Maria Filomena D. Singh. Here's Tiff Atendido Beltran, Supreme Court Information Officer, for this week's Roundup.
This week at the Supreme Court. The Supreme Court on Tuesday, February 25, 2025, resumed the oral arguments on the petitions regarding the transfer of the Philippine Health Insurance or PhilHealth's excess funds to the National Treasury. Associate Justices Alfredo Benjamin S. Caguiwa and Amy C. Lazaro Javier led the interpellations. The oral arguments will resume on March 4, 2025 at 2 o'clock in the afternoon. In its en banc session on the same day, the court required respondents' House of Representatives, its Secretary General Reynold S. Velasco, and the Senate to comment on the petition for certiorari and prohibition with a prayer for a temporary restraining order filed by Vice President Sara Z. Duterte, seeking to nullify the fourth impeachment complaint against her. She claims that the impeachment complaint violated Article 11, Section 3, Paragraph 5 of the Constitution, which states that no impeachment proceedings shall be initiated against the same official more than once within a period of 1 year. The SC also ordered former senatorial candidate Francis Leo Antonio Marcos to show cause within 72 hours from notice why he should not be cited in contempt for his actions, which tend to bring the SC's processes into dispute or disrespect. The court had previously issued on January 21, 2025, a TRO preventing the Commission on Elections from declaring Marcos a nuisance candidate in the 2025 elections. In another case, the court has ordered respondents, House of Representatives et al., to comment within 15 days on the petition for certiorari and prohibition with urgent prayer for the issuance of a TRO and writ of preliminary injunction filed by Ernesto S. Abinos Jr. et al. Against the House probe on posts on social media platforms. Meanwhile, the SC has denied Caloocan City's petition challenging the constitutionality of the Malabon City Charter, citing the failure to follow the proper procedure for resolving boundary disputes under the Local Government Code, or LGC. In a decision written by Associate Justice Antonio Tico Jr., the SC 2nd Division directed the cities of Caloocan and Malabon to settle their territorial boundary dispute before their sanggunians in accordance with the LGC. The same portions of land are being claimed by Caloocan and Malabon, both highly urbanized cities, as part of the respected territorial boundaries. The boundary dispute should have first been referred to the concerned sanggunians for settlement, as provided for by Section 118 of the LGC. In another decision, the court has nullified the foreclosure by the Metropolitan Bank and Trust Company, or Metrobank, of a mortgage property after finding that the bank failed to properly account for the borrower's loan payments. In a decision written by Associate Justice Mario V. Lopez, the SC 2nd Division ruled in favor of Carmelita Cruz and Vilma Lote, who had taken out several loans from Metrobank using real property in Pasig City as collateral. The borrowers argued that while they had paid a total of 32.6 million pesos for their loans, Metrobank only recorded 20.5 million pesos, leaving 12.14 million pesos unaccounted for. The SC annulled the foreclosure sale. It clarified that ordinarily, a lender's failure to provide an accounting of loan payments is not a ground for annulling a foreclosure. But in this case, the SC had already issued a final and executory ruling requiring Metrobank to provide a complete and accurate accounting of the borrower's payments. Until this is resolved, the court said the foreclosure cannot proceed, as doing so would contradict its prior ruling. The Supreme Court has also ruled that a person does not need a documented history of mental illness to claim legal insanity as a defense. In a ponencia by Associate Justice Alfredo Benjamin S. Caguiwa, the SC's Third Division acquitted an accused due to insanity and ordered her confinement at the National Center for Mental Health for treatment. The accused was charged with homicide after her father found her in a disturbing scene over her best friend's lifeless body. She claimed she attacked her best friend after she saw her grow horns and transform into a demon. She also reported hearing the Virgin Mary's voice instructing her to place a cross into the victim's heart. The SC clarified that while prior medical records can be relevant, they are not required to prove that the accused's medical condition led to the crime. Thus, the absence of documented psychiatric history should not be taken against the accused, claiming legal insanity. In another decision, the SC has held that time spent at work under a broken period scheme is covered by overtime pay. In a decision written by Associate Justice Henry John Paul B. Inting, the SC's Third Division directed C. Bren Security Agency to pay security guards Lorenzo D. Cambila Jr. and Albahar S. Samad overtime pay for the 4-hour breaks they spent at work. C. Bren hired Cambila and Samad as security guards, assigning them to Ecoland 4000 residences. Under C. Bren's duty detail order, they reported to work for 12 continuous hours under a broken period scheme, which required them to complete a 4-hour shift, take a 4-hour break, and then complete another 4-hour shift, all within the same day. Under the Labor Code, an employee shall receive overtime pay for work performed beyond the standard 8-hour workday. The SC emphasized that the 4-hour intervals between shifts are considered work hours due to the inability of employees to use the period for their own benefit. On February 26, the court held a preliminary conference on the petition filed by Aquilino Pimentel III et al. Challenging the validity of the Republic Act No. 11954 or the Maharlika Investment Fund Act of 2023. The oral arguments on the case is scheduled on April 22, 2025, Tuesday, 2 o'clock in the afternoon at the SC Session Hall in Baguio City. The Office of the 2025 Sharia Special Bar Examinations, or SSBE Chairperson, Associate Justice Antonio Tico Jr., has announced the extension of the application period for the 2025 SSBE from the original deadline of February 28, 2025 to March 9, 2025 at 3 in the afternoon. The office also issued a notice to applicants regarding the uploading and submission of deferred documents for the 2025 SSBE. Deadline for deferred documents is on May 9, 2025. On February 27, the court, led by Associate Justices Samuel H. Garlan and officials of the Office of the Court Administrator, or OCA, held a dialogue on e-filing in e-court system version 2.0 or e-court PH 2.0 for Region 4A in Santa Rosa, Laguna. Justice Garland delivered the keynote message and the briefing on e-court, while personnel of the SC Management Information Systems Office and the OCA conducted the briefing on e-filing. The dialogue with judges and court personnel of Region 4A followed. Finally, on Friday, Chief Justice Alexander G. Hesmundo was paid a courtesy visit by the Asia Foundation and representatives from Swedish International Development Cooperation Agency at the Supreme Court in Manila. And that's your Supreme Court this week. I am Tifet Indido Beltran, Supreme Court Information Officer.
And that's our podcast this week. Join us again next time for a detailed discussion of select cases decided by the Supreme Court. I'm Attorney Mike Navallo, your Supreme Court Chief Communications Officer. You can catch this podcast on the Supreme Court Public Information Office's accounts on X, Facebook, Instagram, Threads, YouTube, and Spotify. You can also catch previous editions on our website and on Spotify. This podcast episode was produced by the Supreme Court Public Information Office with Attorney Karen Martinez, Jay Rimpilio, and May Sibal as researchers, Brian Austria and Lawrence Olanio as sound editors, and Tyke Flores and Jerome Batumalake as web editors.